Bonjour, Kinamagi and Ireland Indigenous, and welcome to today's edition of Social Studies Explorer. Today's edition, the Judicial Branch in a Flash. All right, so the judicial branch is the court system. So that's what we're going to be talking about today. There is a judicial branch at the federal level, at the state level, and at the tribal level. So we have this particular branch at every level of our government, minus most cities don't necessarily have one, but they're represented by other courts there. So it's all about the robes. I don't know if I agree, but okay. It's not. The cool black robes judges wear are the first things a lot of people think of when they hear the word judicial. But the first thing you really need to know is how courts were created. The only court the United States Constitution actually creates is the Supreme Court, the highest court in the country. The Constitution also allows Congress to create other courts. When Congress created those courts, the federal court system was born. And the federal courts are going to deal with everything up to and including interstate issues. Federal courts also will represent higher things involving our community here, because the tribal government does not go, bigger cases don't go to state court because we have our own sovereignty. Two court systems. Here's the confusing part. There are two systems of courts in the United States. The federal court system deals with disputes about laws that apply to the entire United States. State court systems mostly deal with disputes about state laws. Each state has its own court system created by its own state constitution. Whether people take their case to a federal or state court depends on the laws involved in the case. The good news is that the state court systems usually work just like the federal court system. And many of our general kinds of crimes will go into just the general tribal court or into a state court. If you are not a tribal citizen and you live, say, in Midland and you get in trouble, you're going to go into the state court system. Which court to use? Each court system deals with certain kinds of cases. Federal courts hear cases involving federal law, the United States Constitution, or disputes between citizens of different states. State courts hear cases involving state laws or the state's constitution. They also deal with disagreements between citizens of the state. State courts normally resolve the kind of issues you hear about in everyday life, such as family matters, accidents, crimes, traffic violations. However, there are a number of national forests around our state. Those would actually go to federal court because the federal government has jurisdiction on that land. However, the federal government is not really worried about your speeding ticket if you're appealing it. Criminal versus civil. Most trials you see on TV involve a person who has been accused of a crime. But criminal cases are not the only kind of cases that go to trial. Sometimes people have a disagreement that they can't resolve on their own. Often one side feels that the other side violated their rights in some way. This kind of case is called a civil case. The goal of a civil case is not to find out whether someone is innocent or guilty, but to decide which side's version of the story is correct. You're on trial. The trial court is the first court to hear a case. Both the state and federal systems have trial courts. In the federal system, the trial court is called a district court. In the trial court, lawyers use evidence to try to prove that their client's side of the story is what really happened. Evidence can be almost anything: witnesses, videos, photographs, a letter, piece of fabric, or even a murder weapon. In a jury trial, a group of 12 people listen to the evidence and decides who wins the case. That decision is called a verdict. In a bench trial, there is no jury, so the judge gives the verdict. At the state level, we refer to the district court as a circuit court, and most times the jury will not be 12 people large. Speaking from personal experience, I served on a jury. 7 of us listened to the case. 6 of us were the voting members. Yes, somebody actually sat through the whole trial and then had to leave. And then the 6 of us returned to decide whether the states had proved their case. It's one of your responsibilities as a citizen, and it's one that must be taken very seriously, because someone's fate is literally in your hands. So it's not over until it's over. Losing in the trial court doesn't mean the case is over. If the losing side thinks there's been an error, they can ask a higher court to review the verdict and replace it with a different decision. The courts above the trial court are called appellate courts. The federal system and most state systems have 2 appellate level courts, a court of appeals and a Supreme Court. Your state might have a different name for these courts. Asking an appellate court to review a case is called making an appeal. So you can see the levels here. We start out at trial court. There's a verdict, whether it be a judge or a jury. The losing side disagrees. And it's quite often, if the losing side is the accused, the defendant, they can say, well, this wasn't fair in the case, and they can ask the Court of Appeals to to review it. Sometimes that Court of Appeals will say, yep, that wasn't fair, and they will order a new trial. Sometimes they will say, you know what, this was a crime. The case was handled fair. Your appeal is denied. That happens quite often. But sometimes you'll lose at the Court of Appeals and still be able to ask the Supreme Court to review that decision. So you might lose in the trial court, you might lose at the Court of Appeals, and then win at the Supreme Court based on constitutional precedent. Going up and sometimes down. Want to sound like a legal eagle? Then you can say that the case is brought up on appeal. Cases are thought of as going up through the court system. A trial court decision is brought up to the appeals court. An appeals court decision is brought up to the highest court. Once the case has been heard by the highest court, there is nowhere left to go. Appellate courts review lower courts' decisions to see if a mistake was made. When an appellate court makes a decision, all lower courts must follow that decision in the future when the same issue comes up again. And it's quite frequent for major questions to end up in front of the Supreme Court for them to set precedent. Sometimes if they see that the trial court made an error, they will say, well, this wasn't fair. We're going to send it back to trial court to redo the trial. Judges and more judges. When a trial court only has 1 judge, most Court of Appeals cases are heard by 3 judges. When more than 1 judge listens to a case, the group of judges is called a panel. Usually the judges decide the case by a majority vote. At the appellate level, there is never a jury. That's because a jury's only job is to look at evidence and decide what happened. In an appellate court, the judges are deciding whether legal errors have been made. For the losing side in the Court of Appeals, there's only one more chance, the Supreme Court, which is the highest court. And even amongst the Court of Appeals, quite often the panel will be a 3-judge panel, and they'll decide whether the full appellate court should hear the trial and hear the questions and make a decision. Sometimes they will simply just reject it out of hand and say, nope, not going any further. And that's final. At the United States Supreme Court, a panel of 9 justices hears the cases. State Supreme Courts often have fewer justices. I think there's 7 here in Michigan. The Supreme Court gets to choose which cases to take, and it doesn't take very many. Often cases that make it to the Supreme Court are disputes about whether a law goes against the Constitution. Once the Supreme Court has said something is unconstitutional, that's it. Only the court itself can reverse that decision. The power of deciding what is constitutional is called judicial review. The U.S. Supreme Court has this power over federal laws. State Supreme Courts have this power over state laws. This is why there's such a huge interest when there is an opening at the Supreme Court. And the Supreme Court only has openings one of two ways: the retirement of a justice. So a justice can say, you know what, I've been here long enough. I'm going to retire and live out my life without this responsibility. And most frequently, the death of a Supreme Court justice. That happened earlier, well, last calendar year in 2020 with the death of Ruth Bader Ginsburg, seen on the right here in the front row. And when there's an opening on the Supreme Court, the president gets to appoint a nominee, and then the Senate decides whether they will approve of it. It has happened where the president has appointed one, and the Senate just said, "Yeah, we're not really going to look at it," and just let the president's term expire. Lots of controversy now when it comes to these appointed justices. I guess technically there is a third way. The Senate can impeach. Well, the House can impeach and the Senate can convict a Supreme Court justice, but that is exceedingly rare. So not one that many people even take into consideration. Now, if you're in the in-person part, you're going to have to decide. You're going to have a worksheet to complete, and this one's just extra bonus if you want to do it. In the in-person group, you're going to complete this in a pairing. If you are online, portions of this will be filed in your Google Classroom as a Google form, and then you can complete it there. If you have any questions about the judicial system, please feel free to reach out. I'll be happy to help you. Have a minute, Minwa, Bama P.